Gary on Farrar International LLP and the Commissioner for Customs.
Yes, Mr. Singh.
Good morning, my lords, my lady. Yes, I appear for HMRC, the appellant. I'm assisted by Mr. Gold, who sits behind me, who's been helping with the authorities bundles.
Right.
And my learned friends, Mr. Mill, the King's Counsel, and Ms. Belgrano appear for the respondents, Gray and Farrar.
Indeed.
May I just check that you have all the bundles and so on that you...
Well, we've got a lot of them. We've got a core bundle, a supplementary bundle, 2 bundles of authorities, and an unagreed documents bundle.
Yeah, so the unagreed documents bundle just consists of things like pleadings, witness statements, kind of things that the practice direction indicates can go into a supplementary bundle. But I understand that the respondent thought they weren't really necessary. But I also understand that the respondent would probably not object if you felt there was something in there that you needed to look at. So, for example, a skeleton argument below, that kind of thing. So we're happy to proceed on that basis.
Fine.
If you
I can tell you that we have read, obviously, both decisions of the first tier and the upper tribunal, and we've read the skeleton arguments.
Yes, thank you, my lord. So there are, as you will know, there are 4 grounds of appeal against the upper tribunal's decision. The first 2 broadly concern the predominant element issue, and I intend to spend most of my time on them. The first ground is that there is no mandatory predominant element test. The second ground is that if there is, the upper tribunal erred in its characterisation of Gray and Farrar's supply, which HMRC say failed to be categorised as an introductory service, whatever test was used. The third ground is about the meaning of services of consultants, and the final ground is to do with construction of the phrase data processing and provision of information. Now, the overriding point HMRC make, and I apologise if I do repeat this as I'm going through the grounds, because it does to some extent or other underpin a number of the grounds, is that the economic and commercial reality is that Gray and Farrar supply the service of introducing their clients to prospective long-term partners. So we argue that the supply, it's not consultancy, it's not the provision of information, it's that introductory service, and that is what the contract indicates, that is what the economic purpose of the contractual arrangements is, and that is what the typical consumer is after. So I apologise in advance if I now repeat that point a few times during my submissions. But that is the kind of HMRC's main big point. So I was going to begin with ground 1. Now, ground 1 is that the upper tribunal, I refer to as a UT, just for convenience, was wrong to find that it was an error of law for the first-tier tribunal, or FTT, not to consider what it called the predominant element test. And in other words, what we say is that the FTT was not legally required to consider whether there was a predominant element in the supply and then characterise the supply by reference to any such element. It may be worth just bringing up the grant of permission by Lady Justice Andrews now. It's in the core bundle. It's it's page 3 of the book. And you'll see that in paragraph 2, Lady Justice Andrews says, it is arguable, second sentence, it is arguable that the references in the European case law to a predominant element were not intending to set a legal test, and that what is required is an identification of the essential characteristics of the activity in question. If, on a correct analysis of the case law, they are different expressions of the same concept and derived from the same jurisprudence, it is at least arguable that the FTT was correct to conduct the analysis in the way in which it did. And we agree that there is no legal test requiring consideration of whether there is a predominant element. And then the second point that Lady Justice Andrews made on ground 1, paragraph 3, was, in any event, the need to resolve the apparent conflict between the English and European authorities, which on a proper analysis may not exist, provides a compelling reason to grant permission. And we say on a proper analysis there is no clear inconsistency. That's our position.
There is a clear.
There is no clear inconsistency. So what I was going to do was begin by looking at the 2 key European cases, which are Levob and Mesto-Zamberg. So may I ask you to go to level? That's in the authorities bundle. It's item 27 or tab 27, depending on if it's on a hard copy or electronic copy. Page 520, if that's better.
Yes.
Yes, and there's a summary of the facts just on 520. We can see what that says. And there was an issue in this case as to whether there was one supply or two supplies. The two potential supplies being the supply of goods in the form of software and the supply of services in the form of customization of that software, or the Dutch market and so on. And the Court of Justice decided there was a single supply, and the issue was then how should that single supply be characterised. And the relevant guidance we have is at paragraph 27 of the judgment. I should apologise, my lord. The sidelining here is it should be on the judgment, but the paragraphs in the AG's opinion have been sidelined by mistake. Sorry about that. So it's paragraph 27 of the judgment is relevant, and it's page 543.
Yeah.
So what the Court of Justice said was, secondly, with regard to the question whether such a single complex supply is to be classified as a supply of services, it is vital to identify the predominant elements of that supply. See inter alia Farrar Gelting. Now, in level, there actually was a predominant element, which was the service of the customization of the software, namely the goods, to be used in the Netherlands, which involved, amongst other things, translating the software into Dutch. And the court explained why that predominated at paragraph 29, because you see that it says, on the basis of these criteria, etc., correctly concluded there was a single supply of services, since those criteria in fact lead to the conclusion that far from being minor ancillary, such customization predominates because of its decisive importance in enabling the purchaser to use the software customized to its specific requirements which it is purchasing.
Well, that's what the court says about the fact, isn't it?
Yes.
But, if we just look at 27,
yeah.
The word vital is a strong word to use.
Yes, it is, yes. But then I'll have a look at Mesto-Zamberg as well, and that concludes by saying what we said is interpretative guidance. So that does seem to row away from there being a kind of mandatory test, if indeed this case indicates that there is one. So there was a predominant element in this case, and indeed it's noteworthy that the predominant element was consistent with what the court identified at paragraph 24 as the economic purpose of the transaction. Because if we have a look at paragraph 24, with regard to the dispute in the main proceedings, it is apparent as held by the respondent.
Well, unless the software had been adapted, it wasn't of any use to the buyer.
Yes, exactly. Yes, and then they say yes, exactly. So the customization was consistent with what the economic purpose of the contractual arrangements was. And I say that the use of a predominant element there is synonymous really with essential feature or essential characteristic. Because if we just were to substitute the words predominant element, let's say for essential characteristic, which is a phrase Lady Justice Andrews used when she granted permission, the judgment still makes complete sense. Well, I don't think there's any kind of, any real difference between a predominant element and an essential characteristic. It's something that is very important to the typical consumer, and the phrase used was it's of decisive importance here.
Well, I mean, were there not two essential characteristics here? You had to have the basic software, and then you had to have the customization.
Yes.
You had to choose between them.
Well, yes, but I suppose when we're looking at what is essential, I mean, we could say that means what is the most important to the customer. And that's really what the court held, that the factor of decisive importance was the customization. So I say it's certainly not a million miles away anyway from asking what the essential feature or the essential characteristic is.
What's the difference between most important and predominant?
Well, so nothing. That's the point. That's what that's my point, my lord. That there is really nothing different. So saying it's a predominant element isn't really too far from saying, well, it's an essential characteristic, it's an essential feature, it's the most important thing. That's what I say. It's not as if a predominant element is a world away from what an essential feature is or an essential characteristic is. So I say that Lady Justice Andrews was right when she granted permission to suggest that on analysis, so long as the tribunal is looking at what the essential characteristics are.
But if there are several, surely
yes.
you have to find out which is the most important.
Then yes. If there are several important characteristics, shall we say, then you have to identify which is the most important. Well, you can identify which is the most important, and then on the basis of that, you can categorise or characterise the supply accordingly. But we say you don't have to do that, and the English cases are quite clear that you don't have to do that. That you can look at everything. You can say one thing is the most important, or in other words, the predominant element. But you can still decide that overall, what the customer is contracting for, what the economic purpose is something else. So it's not just what the main element is, but it could have a different description.
I mean, I followed the argument that you can decide that the characterisation is something else, but that's slightly different from talking about essential characteristics, isn't it? So, misremembering cases, the English case about provision of education where you supply lots of books and they make up a lot of the value of what you're providing. I mean, the books are an essential characteristic. So you're not applying an essential characteristic test, you're still looking for an overall economic purpose.
Yes, but I suppose so long as, however you identify the overall transaction is consistent with what the consumer is ultimately after, then it's fine. Then it may not have the same characterisation as whatever is the main element in the supply. That's really the point. So
you would explain Le Bob as saying that the consumer in that case was after functioning software of use in its own business.
Yes. So then the next case is Mesto-Zamberg, which Malone and friends rely heavily on, and so did the Upper Tribunal, and that's tab 30 of the authorities bundle. And I mean, just by way of summary, the facts were that the customers paid a fee to enter an aquatic park, which included facilities for engaging in sport, as well as amusement and rest. And one of the questions was whether, if there were a single supply, that single supply was closely linked to sport. And then, may I just ask you to go to paragraph 29 of the judgment. So here we go. So what the court says is, in order to determine whether a single complex supply must be categorised as a supply closely linked to sport, although that supply also includes elements not having such a link, all the circumstances in which the transaction takes place must be taken into account in order to ascertain its characteristic elements, and its predominant elements must be identified. And then what the court says at paragraph 30, it follows from the case law of the court that the predominant element must be determined from the point of view of the typical consumer. And then if we look at paragraph 33, what the court said here was, as for the question whether, in the context of a single complex supply, the predominant element is the opportunity to engage in the sporting activities, or rather pure rest and amusement, it is necessary to make that determination from the point of view of the typical consumer, who must be determined on the basis of a group of objective factors. And then they indicate the factors that were necessary to look at in this particular case. The design of the aquatic park, resulting from its objective characteristics, namely the different types of facilities offered, etc. And then at 34, they make the point that in regard to the aquatic areas, it's necessary to look at whether they lend themselves to swimming of the sporting natures. They're looking at whether they're divided into lanes, as opposed to, for example, being a glorified paddling pool, which would suggest that it's more for rest and amusement. And then they make the point they do at paragraph 35. And then at 37, what the court says is that having regard to the foregoing, the answer to the second question is that 1321M must be interpreted as meaning that access to an aquatic park offering visitors not only facilities for engaging in sporting activities but also other types of amusement or rest may constitute a supply of services closely linked to sport. It is for the referring court to determine whether, in the light of the interpretative guidance provided by the Court of Justice in the present judgment, and having regard to the specific circumstances of the case in the main proceedings, that is the position in that case. So that's quite interesting, I say. The use there is of the phrase interpretative guidance. They're not suggesting that one has to have a kind of mandatory test that always has to be applied. And going back to card protection plan, the court... Sorry.
It might be said, might it not, the interpretive guidance which
Yes.
the court has laid down is in paragraph 29,
Yeah.
which says that the predominant element must be identified.
Yes.
Again, must is quite a strong word.
It is, but then calling it interpretative guidance rather than kind of rule or anything mandatory does suggest that there may be a case where it's that kind of analysis is not appropriate. I mean, this case assumes that there kind of is a predominant element. What if there is no predominant element? How would it be possible then for a tribunal or court to identify the predominant element?
I understand that, but
Yes.
it might be that the rule is that if you can identify a predominant element, you should.
Yes. Yes, it may be, that may be the case, my lord. But I say these cases don't go... I know it's difficult for me to make a decision because the language used is quite stark. You know, it's, you must identify the predominant element and so on. But in order to reconcile these cases with our own domestic cases, I say one legitimate interpretation is that this is guidance, and clearly it cannot be applied in every case because you may have the case where there's no predominant element. So, you know, that's an example. And it may be that you have a number of elements. Maybe you do have a predominant element, but you feel that the better characterisation is something else. And the Court of Justice wouldn't stop someone doing that. They wouldn't say to a court, well, you've acted unlawfully.
Just as that last point,
Yeah.
where you say you could have a predominant element, but you think the better characterisation is something different.
Yeah.
I wonder if that's a real dichotomy, in the sense that the judgments say you look not merely at the quantity, but you look qualitatively.
Yeah.
So you might have a case where, as a matter of value, some element is predominant, but looking at things quantitatively and qualitatively, you conclude that still isn't the predominant element, and that would be consistent with the predominant element test.
Yes, although in some of the English cases, for example, I'll come on to Byram or Salon 24, the misuse in that case used the room, which was considered to be the main element. So you can say qualitatively that was also the predominant element, but nevertheless the supply was not characterised by reference to that element. I of course accept there is a tension here between the these European cases and the domestic law. I accept that.
But our task surely is not necessarily to reconcile the domestic law and the EU law.
No, yes.
Our task is to find out what the EU law is and then apply it.
Yes.
And if the domestic courts, right up to and including the House of Lords, have not applied the EU law, we must apply EU law.
Yes, of course. Yes, my lord, yes. But I say that they can be reconciled, that is possible. One doesn't have to reach the conclusion that they are so different that our courts have been getting things wrong.
One snag that occurs to me is you find in one of the cases, the Advocate General, I think, talking about the concept of cause, which you get obviously in European law.
Yeah.
And that's not a concept we're very familiar with.
No. Yes, I'll come on to that case. That's I think that's Advocate General Tisano in Mirror Group. I'll come on to that a little bit later. But yeah, no, you're right, my lord, that there are different concepts in play at the European level. But I mean, my second ground is that none of this really matters very much because whatever approach we take in this case, we end up with the characterisation as an introductory service.
Well, that I understand.
Yes, but of course I have to persuade you on the first ground as well. And I say that we can reconcile the decisions. Let me just see if there's anything more I want to say to you about Mesto Zandberg, my lord. Yes, I don't think there is. So if we look at the decisions of the Court of Appeal and the Supreme Court in this country, they have never recognised the test that requires a single composite supply to be characterised for VAT purposes.
Do any of them post-state mesto?
Some do. So there is.
There's only one tribunal. One Upper Tribunal.
Tribunal.
You said Court of Appeal and
Court of
Supreme
Appeal.
Court.
Yeah, so
none of them post-state
You're
mesto.
right. You're right, Melanie. The only thing that none of them post-state mesto Zambia.
No.
That's definitely right. And in fact, we have Baxendale in the High Court, which post-states level, and there was an appeal to the Court of Appeal, but the Court of Appeal didn't say anything about this point. So you're right, milady, that none of them post-state these cases.
It's the decision of Mr. Justice Mann and Judge Greenbank, isn't it?
That's Metropolitan International Schools. That's the one that has a kind of more detailed analysis. And that is post-Mesto Zambia. But I think that's the only significant case that is post-Mesto Zambia. Now, may I just ask you, but my submission is that even though the cases were decided before Levov, some of them before Levov and Mesto Zambia, they're not now wrong in law because of Levov and Mesto Zambia. So the conclusions were correct and the approach followed was permissible, even as a matter of European law. So may I just ask you to look at a case decided before Levov? I think that's a case my Lord referred to, the Books case, College of Estate Management. So that is tab 9 of the authority. And broadly speaking, what happened in this case was that the college provided distance learning courses, and the supply consisted of the provision of printed materials and other elements, such as attendance at face-to-face teaching sessions. May I just ask you to go to Lord Rogers' judgment at paragraph 10. Sorry, it's actually paragraph 11. So he points out at 11, the second sentence, they, the commissioners this is, persuaded both the tribunal and Mr. Justice Lightman that the supply of the printed materials by the college was ancillary within the meaning of card protection plan to the college's principal supply of education. They advanced an argument to that effect in support of their appeal to your lordship's house, but it is hard to swallow. After all, the tribunal found as a fact that the average student was expected to spend about 94% of his time using the printed materials. Taken together, the remaining elements, including face-to-face teaching and sitting examinations, counted for only 6% of the average student's time. Supplying the printed materials for the students was therefore by far the main method by which the college provided them with an education. And then there's some discussion of some of the cases. In paragraph 13, Lord Rogers says, in the present case, the tribunal, having taken into account all the factors, concluded there was one supply, which was the provision of education. They were entitled to reach that conclusion on the basis of the findings which they made, especially their finding that the students took the courses in order to obtain the relevant qualification offered by the college. The transaction was therefore one which gave the students the opportunity, by successfully studying the printed materials and completing the other necessary steps, to obtain a valuable qualification. That was what the students were purchasing. So even where the main, or one could say predominant, element of the supply was the provision of printed material, if the reality was that what the students were purchasing was education, it was permissible for the tribunal to characterise the supply as one of education. So, except of course this is before level, but I say there's nothing there's nothing wrong in law there about what the House of Lords did. That it looked at what the kind of key factors were to the tribunal. It looked at what the purpose of the students was, so the aim of the typical consumer, and it was lawful for the House of Lords to say, well, we think it was open to the tribunal to find.
Well, the reasoning seems to be, what were the students buying? They were buying the education.
Yes.
How was it provided? By the books.
Yes.
And that's the means of providing.
Yes.
as Lord, the main method by which the
Yes.
college provided them with an education, as
Yes.
Lord Roger says at 11, was
Yes.
through the books.
Yes. Yes, exactly. But if let's say we were going to try to break this supply down into sub-elements and identify a predominant element, one could easily say the books were the predominant element. But nevertheless, the supply overall is not characterised as books or as printed material. Now, the case of Byram, this is a High Court decision of Mr. Justice Warren. This is post-level, so and we say that the reasoning here is correct. And the brief facts of this case were that the taxpayer provided misuses.
Sorry, where
I'm
are we
sorry,
now?
I'm sorry, my lady. It's
10.
item 10.
10, so sorry,
Item
Byron. Yeah.
Yes. The brief facts were that the taxpayer provided masseuses with massage parlour services, and they were the phrase I think the High Court used was they were akin to prostitution, and the main element in the supply was the provision of a room where the masseuse could go with the client. Now, I would just ask you to have a look at some paragraphs in this case. So, may I just ask you to? So if you go to paragraph 36, Mr. Justice Warren there refers to a passage from the judgment of Lord Justice Laws in FDR. And
Sorry,
then,
yes, I see.
yes, and then he says, just after the extract, I would add to that several elements can constitute a single supply even where one element is dominant. Dominance does not necessarily identify the overall supply. That's what he says at paragraph 36. And then paragraph 37, he refers to the House of Lords judgment in College of Estate Management. And then he says, shortly after, the ECJ gave judgment in Level. And his view is that the case shows the ECJ adopting a similar approach to the House of Lords. And then, may I just ask you to read paragraph 40? It's quite a long paragraph.
Paragraph
40.
40. Yeah. Yes.
And then at 43,
Can the last part of that paragraph stand with Mesto?
no, because Mesto obviously was about a service and a service. So yes, but it's a correct description of level, I would say. But no, it can't. Not in light of Mesto's amber. And then 43 refers to Lord Roger in College of Estate Management using the phrase an overarching single supply to describe a single supply resulting from several elements. Those words suggest that there may, and indeed I think often will, be a generic description of the supply which is distinct from the individual elements. In many cases, the tax treatment of that overarching single supply, according to that description, will be self-evident. Mr. Justice then refers to the Dr. Bainey case, which I'll take you to briefly a little later, and also to a College of Estate Management. And at 46, he says, it seems, therefore, that a single supply is capable, in some cases at least, of attracting a different tax treatment from that which would be attracted by even the main element within the supply. And then finally, if we have a look at paragraph 70, so 4 lines down into paragraph 70, he says, the description which reflects economic and social reality is a supply of massage parlour services, one element of which is a provision of the room. That, in my judgment, is a correct conclusion, even if, which for my part I think probably is the case, the provision of the room was, to the masseuse, the single most important element of the overall supply, and indeed one predominating over the other elements taken together. So that's what Mr. Justice Warren said in Levov. I was actually then in a case in the High Court called Holland and Vigdor, where my opponent argued that what he'd said there was inconsistent with European authority, particularly Levov, because there was a predominant element test. So it may be worthwhile just turning that case up. That's tab 11. And if this was a hairdressing case, I don't think we need to worry too much about the facts. If I could take you to paragraph 63.
Paragraph?
63, my lord, 63. And may I just ask you to read paragraph 63 to yourselves? And then a further submission was made at paragraph 70 on behalf of the taxpayer. So it may be worth just reading the first few lines of paragraph 70. So Mr. King there was relying on paragraphs 27 of Levov and also paragraph 29. And you can see that at the end of paragraph 70, he pointed to that as an example of the identification of the predominant element of the supply as a determining factor in the categorization of the overall supply. And then at paragraph 71, about 4 lines down, he submitted that it could not be correct, taking a hypothetical example to give to a single indivisible supply made up of several elements, all of which individually are exempt, a label or description which does not attract any kind of exemption. He submitted that insofar as Salon 24, Tumbletots and Denia was a decision of Mr. Justice Briggs, as was Tumbletots, suggests that such a supply may attract a description which reflects economic and social reality, phrase used by Mr. Justice Warren, Salon 24, Byram, or that in the words of Mrs. Justice Briggs in Tumbletots, it may have a unique character enjoyed by neither of the constituent elements of the supply. They are incorrect. And then 72, he submitted that it was incorrect to approach the question of categorization by asking the question, how can the overall supply be best described or labelled? And having answered that question, see whether the description or label is to be found in any list of exemptions. There was, he submitted, no warrant in ECJ jurisprudence for such an approach. And then at 73, he said he accepted that the test for determining what precisely is meant by predominant was not something that ECJ jurisprudence has spelled out, although he submitted that the matter was to be looked at from the point of view of the consumer, the recipient of the supply. Now, what Mr. Justice Blackburn concluded at paragraph 78 was, well, you may just want to read paragraph 78 to yourselves. It's important also to note paragraph 79, where he actually didn't think the question was that straightforward, and he didn't think it was act clair, although there was no need for a reference for the reasons he gives in 79. So he recognises there clearly is a tension, but doesn't go as far as to suggest that what the courts have been doing in this country up to date is wrong, up to the date of this judgment. And there's one more High Court case I just asked you to look at, which is Baxendale, very briefly. It's tab 12.
Tab
12.
Yeah.
And this concerned the provision of a weight loss programme. So customers were provided with food packs and support services such as counselling, and Mr. Justice Morgan adopted the Byram, the Salon 24 approach, to the classification of the single supply, and we really get that from paragraphs 76 and 80. Although he does say that he wasn't asked to actually apply any different an approach. This is at the bottom of 76.
Yeah.
And then just at 80, his view is that the tribunal held that if one apportioned the consideration between food and support services, the right apportionment was 2-1. The taxpayer actually argued it was 91-9 in favour of food. And then a few lines down, nor does it cause me to question my conclusion that if the supply is a single composite supply, it is not a supply of food, but is a supply of services. As is pointed out in Byram, in case of a single composite supply of 2 or more non-ancillary elements, it may be appropriate to find that the character of the single supply is different from the character of any dominant element in the single supply. And then this case did go to the Court of Appeal, but there was no specific comment by the Court of Appeal on the Byram approach. So I don't think you need to look at the Court of Appeal's decision, although it is in your bundle. So then we have Mesto Zandberg as well, after sometime after this case, and we have the Upper Tribunal in Metropolitan International Schools trying to reconcile everything, which is hard, because there does seem to be a very clear tension. And the facts in Metropolitan International School, well, this case is at item 15, tab 15 of the bundle. The facts were not too dissimilar to College of Estate Management. So the school provided distance learning courses. The supply included manuals. Other elements included phone and email support. The First-tier Tribunal decided that the manuals were the principal or alternatively predominant element in the supply, and therefore there was a single rated supply of books. So they reached effectively the kind of opposite conclusion to the tribunal in College of Estate Management. And the Upper Tribunal said no. The Upper Tribunal decided that most of the other elements had value in themselves. The supply was a package, and that package was not 0 rated. Now, if I could ask you to look at paragraphs 54 and 55 and just read them to yourselves. Ms. Metrofanos here was counsel for HMRC.
Do you agree with that approach?
Yes.
So if there is a predominant element, you must identify it and...
Well, they say that if you can identify if there is one, no, but we have to see what else they say a bit later on, lady.
Well,
so you can't have this.
So 54. Do you
Yes.
agree with 54, or do you say that goes too far?
No, so if the predominant element viewed through, because if you look earlier it says matters must be viewed through the eyes of the typical consumer.
Yeah.
So if viewed through the eyes of the typical consumer, there is a predominant element that does characterise the supply. Yes, we do agree with that.
Right.
Yes, you have to look at what the typical consumer, if the typical consumer is after, let's say, books, if that's what they're buying, for example, then one would characterise the supply as books. But you could do that not just by reference to the predominant element. You could adopt the other approach, the overarching approach.
Well,
But
where the Upper Tribunal end up in this case is what you might call a hierarchy of tests.
I'm coming on to that, my lord. And we don't agree with the hierarchy. We don't agree. We don't agree that it's mandatory. So you have to always identify a predominant element, and if you can't, and so on. But I'll come on to that in a moment. But what's quite interesting about this case was that, bear in mind in Lebob it was said it's vital to identify a predominant element. And in 54 and 55, the Upper Tribunal just makes clear that, well, you don't have to find a predominant element. What if there isn't one? Then you can't find one. So in that kind of case, one has to read whatever the court said. It has to be subject to what's possible in a particular case, and so on. And then, if we go to paragraphs 59 and 60, so paragraph 59, the court refers to paragraph 27 of Card Protection Plan, and where the Court of Justice warned that it would not be possible to give exhaustive guidance applicable universally. It must be borne in mind that the question of the extent of a transaction is of particular importance, both for identifying the place where the services are provided and for applying the rate of tax, etc. In addition, having regard to the diversity of commercial operations, it is not possible to give exhaustive guidance on how to approach the problem correctly in all cases. And the Upper Tribunal comments at paragraph 60, we think that that could apply in relation to characterisation. So I say that does help us a bit, because they're saying there that there's not necessarily a mandatory test that has to be applied in every case, because you can't cater for every kind of commercial arrangement, operation, and so on. And then if you go to paragraphs 75 to 78, I think that's where we end up with the hierarchy.
Yeah.
Yes, so I don't know if you just want to quickly have a look over 75 to 78 yourself.
Yeah. So what do you say about paragraph 7?
So we say, well, it makes it clear at least that the overarching supply approach survives Mesto-Zamberg. So it's not as if that's something that's wrong in law. It does at least survive. Where we would perhaps slightly differ from the panel here is that insofar as it could be said that the Upper Tribunal was suggesting that it would be an error of law to not expressly consider the Mesto predominance test, we would say that's not right. I mean, we could say that may be what they're saying, because they begin by saying at 78, the Mesto predominance test should be the primary test to be applied in characterising supply for VAT purposes. So we say, well, if that's not done, but the tribunal still, let's say it follows the overarching supply approach, and it gets to a permissible outcome that way, its decision is not infected with an error of law. So there are different routes to get to the conclusion, different approaches, and it's not an error of law to not consider one.
So it's not a hierarchy.
Yes.
You look at the case and say, is there a predominant element? And if there isn't, you can then look at a different approach. You say there are different approaches.
Yes.
Which
yes.
is a matter of choice.
Yeah, well, it may be that in some cases there's no predominant element.
But if there is
yes.
if the supply is capable of being analysed by reference to the predominant
yes.
element test, do you accept that that is the test to use?
Either that or overarching supply, because you're going to get to the same outcome. So we don't say you have to do it. Let's say in that kind of case a tribunal doesn't do it, but they say, well, the typical consumer wants X, which happens to be the predominant element anyway, but they apply the overarching supply approach and they get to the same conclusion. We say there's no error of law in that approach. I mean, one thing to note is that if we have a look at 107 to 110 of this decision, this, I don't know if you again just want to briefly read those paragraphs to yourselves, but...
Sorry, just hold a minute, 107?
Yes, so it's 107 to 110, and it's just relevant to note that this panel got to the outcome they did through the prism of predominance. So they clearly did approach matters that way. But again, I would just reiterate that it's not mandatory for a tribunal to, in terms, consider predominance in characterising a single supply, but you may just want to look at the analysis there.
Yes.
Yes. So I think that's really what I say on ground one. That there's no mandatory. You don't have to look at predominant element. If you get to a valid outcome through overarching supply route, that's legally permissible.
Just following up
Yes.
on that, do you accept that Judge Hellier went wrong? Because, as I understand it, his reasoning was, well, there's something here that goes beyond the exemption.
Yes. Well,
and that isn't an approach you would seek to uphold.
My Lord, the way the Upper Tribunal characterised that was a description of the overarching supply approach. It was just another way of doing that, because what he said was that, well, it's not just a kind of consultancy, if there is consultancy and provision of information, but there's more going on, there's something else. So I say it is possible to justify that approach by reference to the overarching supply approach. It's not a fourth approach, as in it can be rationalised by reference to the overarching supply route. But it's not exactly what the tribunals and courts have been doing in other cases involving overarching supplies, but his approach was legally permissible.
It might be said he was more looking to whether something was ancillary, and if it wasn't ancillary, then you were outside the exemption.
Yeah, so he did look at that as well. So he said, well, there is the post-introduction liaison, which is a material element. But I think one could say, well, overall his conclusion was there's more going on here. This is not just consultancy and advice. There are other things happening. It's not exactly the way we would have done it, but I say it wasn't legally erroneous. Yes. Now, let's say you don't agree with ground one, you think there is a predominant element test. Our ground two is that the Upper Tribunal, when purporting to apply that test, made 3 errors in characterising the the respondent supply. The first was that it purported to apply the predominant element test without identifying a predominant element. The second is that it purported to apply the predominant element test when no element was in fact predominant. And the third error is that it failed to characterise the supply for VAT purposes as an introductory service.
Well, that's the conclusion you draw from the first two, isn't it?
But there is a freestanding argument on that.
Right.
Yes. I mean, you're right there, my lord. What ground two ultimately gets to is that whatever test is used, Gray and Farrar's supply was of an introductory service and so should have been characterised as such by the Upper Tribunal. So I was going to just go through those what we say are errors one by one. So beginning with the first error, that they didn't identify a predominant element. Again, may I just ask you to turn up the grant of permission by Lady Justice Andrews?
The grant of permission?
Yes, the grant of permission at core bundle page 3.
Right.
It's just that I just wanted to pick up on something she said here.
Yes.
It's paragraph 4, and 3 lines down, she says, the UT judgment is rather confused as to what the predominant element was said to be, and it is arguable, etc. Paras 90 to 91 appear to characterise a predominant element as comprising 2 separate elements. The UT said when refusing permission to appeal that they'd characterise a predominant element as a provision of introductions, but that is far from clear from reading the judgment. In any event, if they had done so, it is strongly arguable that they erred in not characterising the service as a single introductory service. And we agree with her that the UT's judgment is confused. May I just ask you to go to the judgment?
Yeah, we're looking at 90 to 93, 90 to 92, aren't we?
Yes, it's
so at 90 they say that the qualitatively most important element was the introduction. At 91 they say the predominant element was the advice. And at 92 they say the supply is predominantly a combination of advice and information.
Yes, well, yes. So, but at 91, so at 91 they say the advice combined with the information. So at 91, given those findings, we take the view that the predominant element, from the point of view of the typical consumer, was the advice which was provided as part of the matchmaking service combined with the information relating to a potential match. That's 2 elements, advice and information. And the Upper Tribunal do not say which, if any, they regarded as predominant.
Can I just test something there?
Yes.
Suppose both are predominant.
But I would say they can't be, my lord.
You say they cannot
They
be.
can't be.
So, supposing it were the case, I'm not saying that this is this
Yes.
case, supposing it were the case that a supply was predominantly A and or B, and A and B were both exempt, what happens then?
Then you look at what the typical consumer, is after, what the typical consumer wants. And it may be that what the typical consumer's aim is, it could be different than either of them. And that's something that Mr. Justice Warren contemplated in Byram, that you could have elements which individually were exempt, but overall the supply could be characterised as something else.
And suppose the typical consumer thought that what he wanted and what he was getting, his economic purpose was to get A and B, and A and B are both exempt.
Yes.
That's all right. I mean, it's all right, isn't it, to have something that falls within more than one bit of the exemption?
Yes, I mean, it may be in a case like that, there could be two supplies. Whereas in,
well, I follow there could be
yeah.
two supplies, but if the decision is there is one supply,
yes.
the fact that that one supply falls within two bits of the exemption, is that all right?
Yes, in theory, that's okay. If the typical consumer wants two things, and it's possible to characterise that nevertheless as a single supply, it may be fine to say that's exempt because he wanted two things which are both exempt. Yes.
Yep.
Now, may I just ask you to also look at paragraph 84 of the Upper Tribunal's judgment.
84?
84, yes. So it's the second sentence. Judge Hellier's conclusion could only be consistent with the decision of the Court of Justice in Mesto if it could be said that the effect of the inclusion of the post-introduction liaison services within the composite supply was that the combination of the expert advice provided by Claire Sweetingham and the information about a potential match was not the predominant element of the supply. But again, the tribunal there referred to predominant element, but they're talking about two elements. They're talking about a combination of two things, the advice and the information. Now, this was a ground of appeal to the Upper Tribunal, and Lady Justice Andrews referred to what the Upper Tribunal said when refusing permission. And may I just ask you to turn that up briefly? It's page 57 of the core bundle.
Yeah.
And it's paragraph 18 of the refusal, and it's the second sentence. On the basis of the findings of fact made by the FTT, we identified the qualitatively most important element of the supply to the typical consumer as the provision of introductions to prospective partners. And then they refer to paragraph 90 of the decision, which you've just looked at, which says, in our view, the qualitatively most important element was, well, we say, well, if that's the case, on the predominant element test, the supply should have been characterised as a provision of introductions, because they themselves are saying that's the qualitatively most important element to the typical consumer. So what they should not have done, that's the element we could say of decisive importance. So what they should not have done is then break up that predominant element into sub-elements, which is what they appear to have done. And just to give you an example of a case where that happened, Dr. Bainan is quite a good case like that. It was on lots of different...
That's the injections given by the doctors.
Yes, the injections.
Or the pills given by the doctors.
Yeah, pills, injections, and there's the personal administration of a drug. It could be by an injection. And that was held not to be a supply of goods in the form of a drug and a supply of services in the form of the drug's administration, but a single supply of medical services. It may be worth, it's item 8 of the authorities bundle, tab 8. And may I just ask you to go to paragraph 30 and 31, which are from Lord Hoffman's judgment.
31?
Yes, so 30 first of all. So 30, Lord Hoffman is talking about the Court of Appeal decision below. And he says, Lord Justice Aldous acknowledged that at a particular level of generality it could be said that there was one transaction. But he said, when a doctor administered a drug to a patient, he was in reality dispensing the drug to the patient and then administering it. Lord Justice Chadwick divided the transaction to three elements. First, the consultation diagnosis. Secondly, the supply of the drug for the purpose of treatment, and thirdly, its administration. The first stage, he said, was dissociable from the second and third, constituted a separate supply. Although there might be some medical skill involved in the third stage, the dominant element was the supply of the drug, and it was therefore to be classified as a supply of goods. Paragraph 31, what Lord Hoffman says, just after the besides point. This approach seems to me to involve the kind of artificial dissection of the transaction which the Court of Justice warned against in Card Protection Plan Para 29. In my opinion, the level of generality which corresponds with social and economic reality is to regard the transaction as a patient's visit to the doctor for treatment and not to split it into smaller units. And we say that's the error that the Upper Tribunal made here, if there was a predominant element.
I mean, what's tricky is that
Yeah.
this is concerned with whether or not there's a single supply. And in
Yes,
this case,
that's the main-
it's common ground that there is a single supply.
Yes. That is tricky, but I say the point that Lord Hoffman there applies here, that if the tribunal, as they have done, have identified the qualitatively most important element to the typical consumer as a provision of introductions, characterise the supply as a provision of introductions, they then divide it into two of a number of sub-elements, which are information and advice. Now we say the second error,
Just to be clear, if it were the case that introductions was shorthand for advice and information,
yes,
then it would be within the exemption.
yes, because then that's just a labelling issue, then, isn't it? But we say it's a lot more than that.
Yes.
Yes. So we say the second error
Yes.
is that if the introductory service is not to be treated as a predominant element, there was no other element that was predominant. And you've read the first tier's judgment, so you'll have seen that Gray and Farrar do a number of things in providing their introductory services to their clients. So they interview their clients, they create a brief for them, they match them with people they vetted, they advise them, they introduce them to others, which the first-tier tribunal regarded as the provision of information, in that a person's name and number would be provided, and they liaise with them after an introduction. So a number of things. And in my submission, it's artificial to say that any one of those elements is predominant. So from the point of view of the typical consumer, it's not as if any one of those elements is of decisive importance. And just to illustrate that point, why, for example, would advice be any more important than the vetting? Because one of the main attractions of Gray and Farrar is that it's not like an online dating website. They check people, they verify them. Their advertising is all about, you're meeting the right people and the best people. And that's the way they put it. And I just wanted to take you to some extracts from their website which make that clear. It's in the supplementary bundle. It's page 4. The supplementary bundle is short. It's only 23 pages long. It's if we begin at page 4 of the supplementary bundle.
Page 4.
Yeah, page 4. These are extracts from Gray and Farrar's website between 2015 and 2018. And you can see that page 5, so it begins at page 4, and then page 5 is the foreword. And it says, "Welcome to Gray and Farrar, the matchmaking service," explains where they operate, and then final sentence of that paragraph, put simply, if you want to meet the best, then work with the best. And then over the page, we have over 30 years of experience, insight and knowledge in bringing the right people together. And then at page 7, the second paragraph, our clients rely completely on our discretion to introduce them to other exceptional people. And in essence, we are creating for each of our clients an exclusive, bespoke social network that would not otherwise be open to them. And then at page 8, they make the point, this is the second sentence, successful matchmaking is completely centred around knowing the right people and then discreetly and intuitively putting them in touch with each other. And then they say in the second paragraph, our service completely reflects this ethos. And I think there's just one point to make from their website from 2018, and that's just, the text is very small, but it's page 13 of the bundle. Under a wealth of experience, they make a similar point at the very end.
Well, page 30?
Yeah, page 13.
13, I'm sorry, I misheard you. Yes.
And it begins a wealth of experience. And the final sentence is, we have the connections and network to attract the right people for the right people. So there's no reason for why access to this exclusive, curated group of people would be less important to the typical consumer than advice. So we say all of the above elements, all those elements I've just described, were of equal importance to the typical consumer in pursuit of their aim of meeting a person with a view to a long-term relationship. And so it could not be said that any one element predominated. And that brings me on to the third error, which is partly tying up the earlier two, which is the Upper Tribunal erred in failing to characterise Graham Farrar Supply as an introductory service, which we say was the only conclusion open to the Upper Tribunal in light of the economic purpose of the contract, the aim of the typical consumer, and the economic reality.
Well, now here we're
Yes.
dealing with a single supply, everybody agrees that,
Yes.
and it's provided under the terms of a contract.
Yes.
And for instance, at 91, the Upper Tribunal, paragraph 91, they say, well, this is what the typical consumer bargained for.
Yes.
What I find a bit surprising is that they didn't look at the contract terms to see what it was that the taxable person, Graham Farrar, promised to do.
Yes.
And as far as I can see, the only thing that Graham Farrar promised to do was to make introductions.
Yes. I mean, that's the submission we made to them, my lord, that was the only real obligation on the part of Graham Farrar. And the contract is very important. And my Lord just Newey referred to what the Advocate General said, Tisano, in an earlier case. That's Mirror Group. And it may be worth just turning those passages up because they are to do with the contract's economic purpose. And that's at item 24.
Sorry, before you do that, is the contract the terms and conditions for membership?
So
It's page 2 of the supplement.
Yes, you have two versions. You have one which doesn't mention that. So that's the one at supplementary bundle page 2.
Yeah.
And you'll note at paragraph 6 it says we'll charge you £15,000. And then you have essentially an identical version on page 3, but it says we'll charge you £15,000 plus VAT where applicable. The fee must be paid before the service commences. That's page 3.
But one is that
It's
what
identical.
we will do is we
Yes.
will provide you with introductions.
Yes, exactly. Yes.
So both are the same.
Both are the same.
Yeah.
We pride ourselves with a high degree of skill and care we use in providing a service, and we will provide you with a minimum of 8 introductions that we consider suitable, and they define what an introduction is. So yes, that's a contract. That's a relevant obligation. And then when we go, so if I could ask you to go to Mirror Group, which is item 24 of the authorities bundle.
24.
Yes, 24. And it's paragraph 27 of Advocate General Tisano's opinion, and it's at page 463.
Yeah.
And you may just want to read paragraph 27 to yourselves. just for your reference, this passage was referred to by the Court of Appeal in the Tesco case. You don't need to look at it. It's item 7 in the bundle. It's paragraphs 41 and 159. Now, we say that there is
Sorry,
no...
can you give me that again?
I'm sorry, lady. It's
Tesco is at tab 7.
tab 7, paragraphs 41 and 159. So, in my submission, there was no doubt in the present case what the purpose of the contract between Gray and Farrar and his client was. So, Gray and Farrar is a matchmaker. The typical client, as the First-tier Tribunal accepted at paragraph 72, would be seeking a person with a view to a long-term relationship. And the purpose of the contract, as we've seen, and indeed the only substantive obligation on Gray and Farrar, was to introduce the client to a minimum number of prospective long-term partners. So the client getting those introductions in exchange for paying Gray and Farrar's fee was the precise way in which performance satisfies the interests of the parties. There's a case, an Upper Tribunal case in the bundle called Wetheralds, which again I don't think you need to look at. It's tab 16. But the only point I was going to make about it was that at paragraph 36 of that case, the Upper Tribunal considered how the typical consumer would have described the supply, and we say there is no doubt that a typical consumer of Gray and Farrar would describe the supply as introductions to potential long-term partners, or words to that effect, something like that.
Well, they advertise themselves as matchmaking.
Yes, exactly. And we see what the contract says.
Yeah.
And it's really getting those introductions that is of decisive importance to the typical consumer.
Now, I think we're told by the Supreme Court in the Secret Hotels case that we start with contract.
Exactly. We start with a contract, and it may be that the economic and commercial reality goes beyond, simply what the contract says, but it doesn't in this case. That it reflects the economic and commercial reality, and that introductory service was a single service from the typical consumer's point of view. And therefore it should not be artificially split into distinct services of consultancy or similar and the provision of information as the Upper Tribunal did.
Does the Upper Tribunal discuss the terms of the contract and their significance, if any?
Let me just check that, my lord. I don't think they really do. I don't think there's any real discussion of the significance of the contract. You do have our skeleton argument and speaking note in the unagreed documents bundle, where we were stressing how important the contract was, but I don't think they really agreed with us in the decision. Yeah. They didn't really say much about it. Oh, I'm sorry. Okay, yeah.
All right, well, that's ground 2, is it?
I'm sorry, my learned friends are saying paragraph 93.
Paragraph?
Sorry, are you saying paragraph 93? Is that what I heard? I'm not sure if that... I don't think that is relevant to the... I mean, they do refer to the terms and conditions, where they say, 4 lines down, the FDT noted that the provision of the post-introduction liaison was not reflected in the terms and conditions.
Sorry, where are you? 92?
No, it's 93.
93.
So my friends have just, as I heard them mention paragraph 93. There is a reference there, kind of a oblique reference to the terms and conditions. But there's no real...
That's to what's not in it,
yes,
rather
exactly.
than to what's in it.
Yes, yes. There's no discussion of what the customer is really contracting for.
Yes, because I mean they say 4 lines down in 91. It was what the typical consumer bargained for.
Yes.
But they say that without ever looking at what the bargain was.
Yes. I think they must have looked at the contract.
Well, there's a reference to them in paragraphs 5 and 7 of paragraph 10.
Yeah, when they're setting out
Yes,
the
when
FTT
they're setting
findings.
out the
findings.
facts.
Yes, exactly.
That's it.
But no significance seems to be attached to
Yes. So we say that was an error of law. Now, I was asked earlier about the FTT's approach, and I just wanted to say a few words about that. So Judge Hellier adopted this going beyond approach to classification, which is to say that the supply goes beyond any elements falling within Article 59C and therefore must be something else. And we get that from paragraphs 9 and 91 of the first tier's decision. And that does have an overlap with the overarching supply approach. And if you look at paragraph 68 of the Upper Tribunal's decision, they thought it was in essence a description of the overarching approach. Now, the kind of approach that Judge Hellier adopted gained some support from the decision of Mrs. Justice Proudman in the American Express case, and that's at tab 14 of the authorities bundle. And I'll just summarise the facts. So this was a place of supply case. The taxpayer was a company in the UK. Its parent company was in the US at head office level and oversaw real estate matters of the group. Local subsidiaries in various countries dealt with individual real estate properties. The taxpayer acted as a buffer between the parent company in the US and the local subsidiaries that dealt with the properties. It managed the operations of the local subsidiaries and reported back to the parent company, and for that the parent company paid it a fee. Now, there are a number of arguments in play in this case. So the taxpayer was assessed a UK VAT on the basis it made a single supply of services. It raised a single and multiple supply argument, claiming it made multiple supplies to the parent company, and there was another argument that its supplies were connected with immovable property. But one of the arguments was that it provided consultancy services to the parent company and that the place of supply was the US rather than the UK. And there's a relevant paragraph here, which is paragraph 80. And I would just ask you to read that yourselves, 80. It's Mr. Cordaro was for the taxpayer in this case, and it's just worth reading that for yourselves. So Mrs. Justice Proudman's views was that Amex Europe's activities went well beyond what a consultant does, went much further than consultancy activities, really management. And when the First-tier Tribunal, so when Judge Hellier granted permission to appeal to Gray and Farrar, he picked up on paragraph 80, and I just wanted to show you what he said. This is at paragraph 68, sorry, page 68 of the core bundle. I suppose it begins at page 67 of the core bundle. And at paragraph 4, he refers to what Mrs. Justice Proudman said in Amex, and then he quotes from paragraph 80, and I would just ask you to read what he said at paragraph 5.
Sorry, I'm a bit behind you.
I'm sorry.
What are we looking at?
So it's the grant of permission by Judge Hellier to Gray and Farrar to appeal to the Upper Tribunal.
Right.
And it's page 67 of the core bundle.
Yeah.
At paragraph 4, Judge Hellier refers to
Yeah.
paragraph 80, and I would just ask you to look at paragraph 5. Just read that to yourselves. Yeah, so, I mean, what he says, broadly speaking, we would agree with, you know, and in the decision itself, he did seem to adopt the same kind of approach as Mrs. Justice Proudman, and we say his approach to characterisation was permissible. So we would say there was no legal errors. Not exactly how we would have characterised it, but it was a legally permissible approach. I think that's everything I want to say on ground 2. So if you're not with me on ground 1 and you're not with me on ground 2, then ground 3 becomes necessary to consider. And this really centres around the meaning of the term services of consultants in Article 59C. And we say that in finding that Gray and Farrar provided services of consultants, the Upper Tribunal erred in paragraph 42 of its decision in its interpretation of the second sentence of paragraph 20 of the Court of Justice's judgment in Lintor. So that's how narrow the ground is. I don't know whether you want to just remind yourselves of what paragraph 42 says.
Yes, please.
Yes.
Yes.
So if you go to page, so it's in the bundle and it is at page 44. And they really agreed with what the First-tier Tribunal said. So page 44 of the core bundle, paragraph 42. Been able to read that, my lord. I was going to ask you to look at Lindhorst next. You may already be there. Yes. So Lindhorst is tab 21 of the authorities bundle.
Yeah.
And briefly, the facts were that vets in the Netherlands supplied their services to cattle farmers in Belgium. And one of their arguments was that they were supplying services similar to the services of consultants. And I would just ask you to look at Advocate General Fennelly's opinion. Now, the relevant parts of the opinion, they're really from paragraphs 19 to 25.
Yes.
So I just wanted to focus on paragraph 21. And I would just ask you to read from 21C down to the end of paragraph 21. That's what the Advocate General said. And then when we look at what the court said,
So the Advocate General is saying there's no AU stem generis interpretation here. There's no common genus.
That's exactly what it's saying.
They're all disparate activities.
They are, other than the unsatisfactory notion of liberal professions. But then he's earlier said, well, I don't even think that's not really enough. So he's of the view there's really no commonality.
Yeah.
And now if we go to the court's judgment at paragraph 20, which is page 413. So what the court says is that paragraph 20, it should be noted that the only common feature of the disparate activities mentioned in that provision is that they all come under the heading of liberal professions. Yet, as the German government rightly believed, if the community legislature had intended all activities carried on in an independent manner to be covered by that provision, it would have defined them in general terms. So we say in that first sentence of paragraph 20, the court seems to be clear that there is a common feature of the activities listed. This is in the predecessor provision to Article 59C. And they say there's just this one common feature, the only common feature, and that is that they all come under the heading of liberal professions. So then one would think the services of consultants and engineers, which are all mentioned, they're all listed, all come under that heading, the heading of liberal professions. Now, the second sentence, what they appear to be doing there is that they appear to be equating liberal professions with activities carried on in an independent manner. And what the First-tier Tribunal said at paragraph 25 was that typically acting in an independent manner means not dependent on or integrated with a client. So someone like a solicitor, an engineer, would be acting in an independent manner. So they appear, in that second sentence, the court appears to equate liberal professions with activities carried on in an independent manner. So what the second sentence seems to be saying is that the wording, so the provision, does not cover all liberal professions. So it doesn't cover all activities carried on in an independent manner. That seems to be what it's saying.
Yeah.
So just drawing those two sentences together, we would say that what the court appears to be saying is that activities that are mentioned in the provision all come under the heading of liberal professions, but not all liberal professions are covered by that provision. So, in other words, the liberal professions not mentioned in the provision are not covered. That seems to be what they're saying, and we get some support for that interpretation from Mrs. Justice Proudman's decision in Amex.
Well, before we go to Mrs.
Yes.
Justice Proudman,
Yes.
is your interpretation of what the court is saying in Lindhorst affected by what the court said in von Hoffmann or Commission in Germany?
No, not at all, no. We understand that it has to refer to services and so on. It's all about the services. It's not about the nature of the profession, but it's not affected by that, Lord. Because I am going to focus on services. They do nevertheless have to be services of consultants. So if we go to American Express, just I think for the final time, it's item 14 of tab 14 of the authorities file. And it is paragraph 76.
70?
76 of judgment, page 225. So what Mrs. Justice Proudman says is that the services listed are disparate activities, and the only common feature of the first 5 is that they all come under the heading of the liberal professions, see Lindhorst. However, third indent was not intended to cover the activities of all liberal professions, or to cover all activities carried on in an independent manner, see Lindhorst paragraph 20. So our point is that, well, because all the activities that are mentioned in that third indent, now Article 59C, come under the heading of liberal professions, the services of consultants being an activity mentioned in that provision, one of the first 5 that Mrs. Justice Proudman referred to, also comes under the heading of liberal professions, services of consultants. And we say, well, the Upper Tribunal made an error in not finding that. It should have found that the services of consultants came under the heading of liberal professions. Now,
So, well, wait a minute. So,
yes.
what you are saying is that, contrary to the view expressed by the Advocate General,
Yes.
the court found that there was a common genus, theme, whatever you like to call it, namely liberal professions.
Yes.
But if that is right, then how is that reconcilable with what von Hoffmann said, which Mrs. Justice Proudman quotes the relevant bit in paragraph 77, where they say, other similar services does not refer to some common feature of the disparate activities mentioned in 90E.
Yes.
If they've got a common feature, why would the court be describing them as disparate activities?
They're still disparate. They cover lots of different activities, but there is nevertheless that one, and it's an unsatisfactory one. That's what the Advocate General said. But that's the only kind of common thing we can get from any of them. That they are under the broad heading of liberal professions. I think one of the Advocate Generals, I may take you to this, referred to the traditional liberal professions.
Yeah. Well, when you say that that's the only common feature you can get, but perhaps there isn't a common feature.
Well, that's what the Advocate General thought. Yes, but we say the court in Lintor said that there was that one common feature at least. But let's say we do accept that there is. If we don't accept there's a common feature, then this ground is over now. This is the end of the ground, but ground 3. But if we accept that there is a common feature, then we would say that some attempt has to be made at identifying what the key characteristics of an activity of a liberal profession are. Because otherwise, how are we going to know whether something is a service of a consultant or a service of one of the other professions that falls within Article 59C?
It's quite a construct, isn't it? You get a paragraph where the Court of Justice says, it doesn't say it has to be a liberal profession, it just sort of makes an observation.
Yes.
Building on that, you say, well, there has to be a liberal profession. And then you say, which the court hasn't done, in this context, a liberal profession means X, Y, Z.
Yes.
And then you find that this sort of aside from the Court of Justice has become a requirement.
Yes,
that
we
to
did
get
say
the exemption, you had these particular characteristics.
There are quite a few building, but they're not the only ones. There's still some more that I have to describe to you. But we say the reason it's important is because otherwise, if we follow the FTT's approach, just so many different services can qualify as services of consultants. I'll give an example of that. And we accept that neither approach is actually that satisfactory. But we say that some attempt has to be made, kind of ensuring that the gateway is not too broad. And that's why we pick on the notion of liberal professions. So then let's say that these services of consultants come under the heading of liberal professions. That's the kind of first building block. The second building block is that we then have to try to identify what the key characteristics of the activity of a liberal profession are. And we get some assistance from Lintors, because in that paragraph that you looked at of the Advocate General's opinion, 21, Advocate General Fennelly indicated that the characteristics of what he called traditional liberal professions were social and intellectual prestige, based generally on high standards of educational attainment and strict regulation of ethical and professional behaviour. That's what he said. Characteristics, social and he indicated that for the social and intellectual prestige, generally high standards of educational attainment, strict regulation.
Sorry, which paragraph is this?
It's paragraph 21 of the Advocate General's
21.
Yes, opinions. It should be in the passage that we looked at.
Oh, right. Yeah. So that's the but he's rejecting that.
He's rejecting that there is that common feature, but he has nevertheless said what he thinks the characteristics of the traditional liberal professions are. So then we do have another building block in this case, which is we then rely on the case of Christian Urbing Adam, which is tab 25 of the authorities bundle. And I'll just explain what this case was about. So this was not on the provision we're looking at. So it wasn't on Article 59C, formerly 92E of the Sixth Directive. It was on something else.
So they were actually having to interpret the phrase, weren't they?
Yes, they were. Very briefly, the facts were that legislation in Luxembourg applied a reduced VAT rate to activities pursued in the exercise of a liberal profession. Community legislation introduced a new higher reduced rate and allowed member states to apply that new rate to goods and services already benefiting from reduced rates under their national law. And the taxpayer in Christian Urbing Adam was a managing agent of buildings in co-ownership. And she claimed that her activity was included in the category of liberal professions, so as to benefit from the reduced rate. Now, the term liberal profession appeared in the second paragraph of Annex F to the Sixth Directive, which you do have in your bundle. It's tab 5. But that wasn't a reduced rating provision. So that listed activities member states could continue to exempt under the transitional provisions in Article 28.3b. But the court nevertheless referred to that when asking itself what the concept of a liberal profession in community law was. And there were just a couple of paragraphs I wanted you to look at from the court's judgment. And so this is tab 25, and it's, if we go to paragraph 38 of the court's judgment, and you'll see that at paragraph 38 the court refers to Annex F2 at Article 28.3b, and then at 39, however, with a view to providing guidance to the referring court, certain factors which characterise the liberal professions within the meaning of Annex F2 should be emphasised. As the Commission has pointed out in its written observations, the liberal professions mentioned in that provision are activities which, amongst other things, are of a marked intellectual character, require a high-level qualification, and are usually subject to clear and strict professional regulation. So, although the wording used by the court in Christian and the wording used by Advocate General Fennelly in Lindhorst was not identical, they both, in effect, seem to identify the following three essential characteristics, the basic requirements of the activity of a liberal profession. And they are that it will be of an intellectual character. So Advocate General Fennelly says high social and intellectual prestige. The language used by the court is marked intellectual character. And then the second is it requires a high-level qualification, high levels of educational attainment, according to the Advocate General. And then they both agree on the third characteristic, which it should be subject to strict regulation. So I accept this argument is a bit of we're stretching from one thing to another, but we say because services of consultants come under the heading of liberal professions, we would say there is then a test that emerges to whether services are services of consultants, and that is to ask whether they possess those three essential characteristics. And we would say if they do not, then they should not be treated as services of consultants.
And just to be clear, you're not here dealing with data processing and the provision of information. No. It's the services of consultants.
It is, yes. And then if we were to apply them to Graham Farrar's activity, we could have a debate about intellectual character, but I don't think I need to get there. Because on any view, Graham Farrar's activity does not require a high-level qualification, and it's not subject to strict regulation. There is a trade body called the Association of British Introduction Agencies, or ABIA, but that's not a proper regulatory body.
Wouldn't vets have qualified on this test?
So that was a point considered under in the case we were looking at, Lady Lindhorst, where it was said that what they do goes beyond. It goes beyond anything to do with being a consultant or anything similar like that. They're treating animals. They're doing other kinds of things. So that would go beyond that. So that would be an example.
They seem to be saying that the services performed by vets are similar to the services performed by doctors. And since doctors are dealt with elsewhere in the directive, vets can't be within.
Yes, and I mean the point is not all liberal professions. So there may be other professions that have these characteristics, but they're not all mentioned in the provision. So vets are not. So it's only if we would only succeed in this argument if you accept every step along the way. Now, what Mrs. Justice Proudman, I don't think I'll take you to it again, but what she said in that paragraph 80, American Express, was that, which is tab 14, she said, the consultant gives advice based on a high degree of expertise. That's what she said. And we do agree with that statement, but we would contend that advisory services purporting to be services of consultants for the purposes of Article 59C must possess those three essential characteristics of an activity of a liberal profession before they can be said to be provided with a high degree of expertise. And that particular issue was not considered by Mrs. Justice Proudman in American Express. I think there is, I said I wouldn't take you to American Express again, but there may just be one other paragraph that is relevant. So it's again going to tab 14 of the bundle, the authorities bundle, and it is paragraph 78. So you can see what she said there at paragraph 78. It is that it is not enough that the services should be of an intellectual nature, drawing on expertise, or have something in common with the listed categories. I do not accept Mr. Cordara's submission that the third indent should be construed in the widest possible way as a single gateway of intellectual services from the liberal professions. So it is not enough that the services, by which the judge means similar services, because she's just looking at that above that paragraph, should be of an intellectual nature. That's not enough. So this may be a bit of a stretch, but our submission is that there seems to be an acknowledgement, Proudman, that the listed categories do have at least the characteristic of being of an intellectual nature, which is one of what I would say is the three essential characteristics of the activity of a liberal profession. Now, she made a comment there about the gateway, that she doesn't accept that the provision should be construed in the widest possible way, as a single gateway of intellectual services from the liberal professions. Now, the gateway here, on the basis of the first-tier tribunal's approach, would be, as upheld by the Upper Tribunal, would be even wider, because I'll just remind you of what they said at paragraph 8, and they repeated at paragraph 80.
This is the Upper Tribunal.
This is the first-tier tribunal.
First-tier.
Yes, their approach was upheld by the Upper Tribunal. So it's core bundle, page 71.
Yeah.
And you can see what they come up with at paragraph 8. Although this was not common ground, we note here that it seems to us that advice given by a person with relevant experience, which falls within the domain of that experience, is specialist or expert advice, and therefore within the services of consultants provision. And then at paragraph 80, they decide whether they should apply that. They refer back to paragraph 8. So that formulation in paragraph 8 would cover not only intellectual services from the liberal professions, but any service provided by someone with sufficient experience who could therefore be described as an expert. Now, if we look at paragraph 15 of the first tier's decision, they refer there to a tribunal case called the Indian Palmist, in which the liberal professions approach was accepted. Now, because it's a tribunal decision, we didn't include it in the authorities bond. It's not authority for anything. But if we were to apply the first-tier tribunal's approach to a case like that, it would qualify. I mean, the Indian palmist provided clairvoyancy and palmistry services, and that included guidance and advice to his clients after carrying out spiritual and astrological calculations and phrenology, which is a pseudoscience. And he failed in showing that he provided the services of a consultant because the tribunal applied the liberal professions approach that I'm urging upon you. But he would have succeeded on the first-tier tribunal. So he had impressive experience. He'd been practicing for over 30 years. His training started at the age of 6. He followed a family tradition going back 200 years. So his advice was advice given by a person with relevant experience, which fell within the domain of that experience. And so on the first-tier tribunal's test, it was specialist or expert advice and therefore consultancy. And
would it matter if the result were different in the Indian palmist?
Well, we say it's an indication that the test that the first-tier tribunals come up with, as upheld by the Upper Tribunal, is too loose because it treats experience alone on the part of the supplier of advice as sufficient to establish the necessary expertise.
I can see that, because if a mechanic tells me that my car needs new tyres, that's advice from somebody with experience, but not a consultant. Exactly.
Yes, but we would say there has to be, the gateway we've come up with is not ideal, I accept that, but we say there has to be a more stringent test than that, because then all kinds of services that were probably not intended to come under that type of provision would qualify. So palmist, clairvoyant, kind of just about, you can think of so many different examples. So we say the way the first-tier tribunal was interpreted is too broad, and we've tried to come up with an alternative formulation which we would partially...
Of course, within the exemption, you've got not only services of consultants, lawyers, blah, 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 but data processing and provision of information. So within that same provision, one sees that you can get exemption for something that doesn't require anything to do with a liberal profession.
Yes, or you can fall within the place of supply provision. Yes, exactly. But that's because it's only the first 5, as Mrs. Justice Proudman said, that where you have to have the characteristic of a liberal profession. And so you can get within it. If you're providing, we would say, data processing and the provision of information, you can get within it for that reason, but that's not affected by the liberal professions approach, because I think that's after number 5.
I followed that.
Yes.
But it might be said, well, if this particular provision is so intent on the liberal professions, why is it allowing within that same provision things that have nothing to do with the liberal professions? Self-evidently, because data processing and the provision of information are not within the scope of liberal professions.
It's not, but I would say this is really the 4th ground, but I would say it's still quite tightly drawn. It's not intended to cover too many things, but if we interpret services of consultants as the tribunal did, it would cover. It would just be too broad a gateway, in my submission.
And just coming back to the palmist who supplies services to someone abroad.
Yes.
Is it clear that that shouldn't have the benefit of the exemption?
Well, I mean, it certainly doesn't meet the
liberal professions
it doesn't meet
test.
that test, but I would say it depends how broadly we want to interpret services of consultant. We can interpret it very broadly to include a number of things. But of course, I am for HMRC here, and we'd rather it will be interpreted narrowly. And we say it is, there is an argument that what the tribunal did here was impermissible, and that the test is narrower. And we think the liberal professions approach is the best way of narrowing or clarifying what the correct test is. And that brings me on to my final ground, ground 4, which is quite a short ground.
Just
So-
before we delve into
Yes.
the law on ground floor, can I ask you a factual question?
Yes.
In the first-tier tribunal, at paragraph 55 on page 79,
Page 75.
the finding is that the matching of one client to another is not done by a computer program or algorithm. Ms. Sweetingham was adamant she was responsible. And then they say the liaison team would tell her for which clients introductions were needed. She would devise a shortlist using the Salesforce system. What's that?
So I think my recollection
The
from
Upper
the
Tribunal doesn't mention it, and I
No,
couldn't
no.
see it mentioned in her witness statement. But what is it?
So that was where she had, I think, a system of manual cards which listed, or files or papers which listed everything, and she
An
had a
old-fashioned
photographic
Rolodex
memory.
type thing.
Sorry,
An old-fashioned Rolodex type.
something similar to that. I think it was similar to that. And her evidence was that she had a very good memory, and she could just remember kind of what was in it. So she could remember all the different clients and so on. So it's very similar to that. We actually do have the transcripts of all the cross-examinations.
Well, I haven't read the transcript.
Yes,
I
of
just
course.
was curious by what this
But-
was.
Yeah, so that's what it was. It wasn't a kind of automated system. It was really her memory based on kind of
Yeah.
physical documents that she had. Yes, that kind of Rolodex system.
All right, thank you
yes.
very much.
There isn't actually really much law on ground floor, because when we look at the cases, they're referred to by the Upper Tribunal. They don't really decide the point. It's Bank Bruxelles and American Express, I think, which they did use the phrase disjunctively, but there was no argument on it. So our submission is that the Upper Tribunal did err, that there could be a provision of information without any accompanying data processing within Article 59.
What is data processing? You say it has to be done by a computer?
So there is no definition of it in the provision.
Why can't Ms. Sweetingham process data in her head?
So we did have a discussion about this, but that would be in the tribunal, first-tier tribunal, but that we decided that quite wouldn't be enough, because that would be like me walking down the street and just remembering lots of people and treating that as data protection. So I endorsed HMRC's guidance on that point, which is it has to be some mathematical or logical operation carried out on some form of data. That guidance is in the book. That's only guidance, of course. That's not law.
No,
But yes, but we would say
But what about an address book? Is that not processing data? It's arranging data in alphabetical order of surnames with the view to being able to retrieve the data when you need to find somebody's address or telephone number.
I would say that's too loose an interpretation. That would, because I can take you to the relevant guidance, which we do support.
Yeah.
HMRC's guidance, and that's in the bundle. And at the very end, there are some.
In the authorities bundle?
Yes, in the authorities bundle. I'll just make sure I have the relevant part.
But I think that data processing in the data processing legislation is not restricted to computerisation.
No, it's not.
anymore.
No, I mean what
It's just got to be organised in some way.
Yes, I mean, what HMRC say, they say different things in their guidance, but if we look at, for example, their VAT notice 741A from January 2010, this
Sorry,
is
where are we?
tab 32.
32.
Yes.
Yeah.
So 32 at page 597, 15.5.10. What is data processing? For the purposes of para 16.2b, data processing is the application of programmed instructions on existing data, which results in the production of required information. And then they exclude some things from data processing. Services include an element of data processing where this is simply required for a contract to be completed. The nature of the actual contracted services determines which place of supply rule applies. There was no finding as such by the first-tier tribunal that data processing was going on. That's why they said that you only need provision of information. There's no need to decide that point if actually.
Well, you just told us, haven't you not, that the Salesforce system is effectively a manual database of names and addresses.
Yes, but the first-tier tribunal didn't find that one of the activities of Graham Farrar was data processing.
Well, that she would devise a shortlist using the Salesforce system.
Yes.
So she's using a manual database to retrieve details of clients. I mean, is it suggested she remembers clients' telephone numbers without having to look them up?
Well, she said she had a photographic memory, so she remembers a lot. So she's got very good memory. So that was a finding.
It refers to programmed instructions. What do you take programmed to mean?
So there is some other guidance which tells us a bit more about that. Just make sure I give you the right part of it. Yes, so it's tab 35 of the authorities bundle, and it's kind of a manual from HMRC, which is VAT, HOS, place of supply, 132, place of supply of services 13250, and then there is a section on data processing where at page 618, and it says the term data processing is not defined in the place of supply legislation. However, we follow the definition given the Data Protection Act 1984, which is processing in relation to data means amending, augmenting, deleting or rearranging the data or extracting the information constituting the data, and in the case of personal data means performing any of those operations by reference to the data subject. Data processing involves the performing of mathematical and logical operations on data according to programmed instruction in order to obtain required information. Of course, this is
The Data Processing Act 1980, the Data Protection Act 84 is no longer a law.
Yes, that's right, but they've taken their interpretation from that. I mean, none of this is law. This is not what the...
No, I follow.
Yes, but that's just the view they take. I mean, I suppose ultimately my point would be more that if you find there is an element of data processing here, the guidance mentions, well, if actually it's just an element of concluding the contract, overall the supply is for something else, you don't characterise it as data processing. That would just go back to my earlier points.
But to be clear, you don't say there has to be any computerisation involved in data processing.
No, so, well, I mean, it mentions programmed instructions, but strictly you could have that without computerisation, I suppose. So there wouldn't necessarily have to be computerisation. I mean, you could, I mean, normally there would be. For example, you would, let's say you want to work out how much a stock has changed in price over 5 years. You could input the daily price of that stock for the last 5 years into a program, and it would produce a chart, and that would be your information. So I think that is the kind of thing that's envisaged. But I suppose it doesn't expressly say computerised, so it doesn't need to be. And of course, this is just guidance. This isn't law anyway. And there is no definition of data processing, so it's whatever you want it to be, really. But we say, even if there is an element, I go back to my earlier point, that it's the supply here is not data processing.
Yeah.
It's something else. My actual submission on ground 4 is that it's to do with the disjunctive reading. So what the Upper Tribunal in effect found was that you could read data processing and provision of information as data processing or provision of information. And we say that is wrong. And the reason we got to that was because there had been no finding, that by the tribunal, there's no finding of fact that the supply involved data processing, but there had been a finding of fact that it involved the provision of information in the form of the name and the telephone number. So that's why it was an important argument for Gray and Farrar to say, well, you don't need to have data processing because they didn't have the finding of fact which gave them data processing. So and then I suppose I have a simple point on this, that if either data processing or the provision of information were sufficient, then the provision just wouldn't, it would say data processing or the provision of information. It wouldn't say data processing and provision of information. So the fact that both are referred to means that both must be provided in order for Article 59C to apply. And then
I mean, just as a matter of language,
Yeah.
this is a silly point really, but it says the services of consultants, engineers, consultancy firms, lawyers, accountants and similar services.
yes.
Well, that doesn't mean you have to have services of lawyers and similar services.
No, that's right. Yeah, that's right. Except that.
So, and doesn't necessarily mean
It
you
doesn't
have to have
necessarily. That's
both.
true. That's correct. Yes, it doesn't necessarily mean that. And there are other examples in the not in that bit, but earlier, where you can make the same point. But if we were to apply that here and say, well, you can read and as or, that term, provision of provision of information, if considered in isolation, is very general. I would say it's so general and wide that it's not really in keeping with the rest of Article 59C, because that relates to specifically defined services, so services of consultants, engineers, and so on. So we would say that the term, the provision of information, makes more sense when it's considered conjunctively in the context of data processing, as data processing will lead to the production or provision of information. And
just think around that a moment. To come within the exemption,
yes,
whether or not whether one uses the word predominant or whatever, one has to characterise the supply as that. So the mere fact that information might be provided on an ancillary basis or as some lesser element in a supply won't do.
Yes.
So if your supply is essentially predominantly the provision of information to somebody abroad, is it obvious that they should have the exemption?
Yes, because I say, my lord, that would lead to many services potentially falling within the provision that were never intended to, because there are many supplies of services that we could describe as the provision of information in some sense. So just use your example. What if I sent someone a book abroad? That's just an example I thought of now. But you could say that a book is a provision of information, and that you read it and it has information in. It just becomes too wide if it's just provision of information. And again, I will go back to these points, these ground 4 is all assuming I've lost on grounds 1, 2 and 3. And I suppose I make a point now that I have already made, which is that insofar as information is provided by Graham Farrar to the client in the form of the matches name and number, that is only provided as a part of the means of providing the introductory service. And then I go back to my earlier point that the supply should therefore be characterised as the supply of that introductory service, not as the provision of information or the data processing or anything else.
Well, your argument is not borne out by the VAT notice you've just shown us.
So the VAT note, the guidance is
which
broad.
deals
Yes,
separately
yes.
with data processing and provision of information. And amongst the examples of providing information is, for instance, tourist information.
Yeah, so
Well, you might not need to do any data processing for that.
Yeah.
You just read out a leaflet about the attractions of the Tower of London.
so we accept that the examples given are very broad, but the guidance does not reflect the law. And we would say it doesn't necessarily reflect the law, and we would ask you to make a decision on the law, and then the guidance can be amended accordingly.
Of course it can.
As necessary. But I accept that some of the guidance doesn't help me in the points that I'm making, but it is only guidance.
Yeah.
We can't place too much weight on it. My Lords, I think we had 2 days, but I think I've finished already.
Well,
I
was saying to my colleagues before we came in, we didn't really think this was going to take up 2 days.
Yes.
But,
May I just check that there's
glad
nothing...
at least that prediction seems to be accurate.
I'll just check that there's
Yeah.
nothing. So, unless I can help you further, those are my submissions.
Thank you very much. Yes, Mr. Milne.
Please, my Lords and Lady. I will be making my submissions by reference to my skeleton argument, just to try and keep some order on it. But may I just make, I think, 3 initial points that have come up. First of all, if I may respectfully say so, this isn't a case about exemption. and that's quite an
No,
important
it's a
difference.
place of supply.
It's
So
a place of
it's
supply,
not to be
and-
strictly construed as an exemption.
Precisely.
And in most cases, I would imagine, the effect of the place of supply is to transfer the right to tax from one member state to another member state.
Yes.
So it's a conflict of laws
Yes,
type.
exactly. So it's not to be strictly construed. It's as it is. So I'm relieved that your lordships have that point, because it is quite important. And I will, just in going through the authorities and my skeleton, show you a couple of places where they have specifically made that point, that looking at these provisions of places of supply are not the same as looking at exemptions, and not to be strictly construed. Secondly, just while we've had the guidance open, and I entirely accept that this isn't a law at all, but just interesting just to look at the guidance, since we've got it there. It's tab 35, page 617. You see all this stuff about liberal professions isn't in the guidance there. It's consultants. It starts off number 1, market research, advisory services, down bottom 1 of consultants on page 617, auctioneers services, not a liberal profession, I would suggest. And over the page, data processing, they follow the definition in the Data Protection Act, 1984. I'll come back to data processing in just a moment. Provision of information, provision of tourist information, as your lordship has pointed out. Third one down, information supplied by a private inquiry agent. So it's in HMRC's own published view, pretty broad. Just to clear up on data processing, we have, rightly or wrongly, assumed that when it talks about supply of data processing, what they're talking about is making a supply to the customer of data processing, i.e. processing the customer's data, as opposed to using your own data in order to provide advice. And that's, as I understand it, what the First-tier Tribunal were meaning when they dealt with this from paragraph 55 onwards in their decision. If you have that, it's at tab 9 in the core bundle. Paragraph 55 is where your lordship, or Justice Lewison, pointed out, using the Salesforce system, so that the matching of one client to another was not done by a computer program or by any sort of algorithm. Claire Sweetingham was adamant she alone was responsible, and she used the Salesforce system, which, as you say, is, as Lewison says, is a sort of card index, if you like, and she wasn't supplying the Salesforce system. She was just using that as a means of providing the advice and the information, and that's what the First-tier Tribunal said at paragraph 76, I think. Yes, paragraph 76 on page 31 of the bundle. No, not 31.
So you're not suggesting that there was a provision of data processing?
Correct.
Yeah.
I'm accepting what the tribunal said at paragraph 70. Sorry. 76, that's right. It seemed to us that the way in which Graham Farrar provides or creates the advice is not part of what it is providing. Although it uses intuition and experience to give advice, it is not supplying the activity of using intuition and experience. Rather, it is merely using that as a tool to formulate the advice and to decide on the information it gives to the client. The knowledge and calculations of the engineer, a questioning of the client as to the required capacity of the bridge, and the textbook research of the lawyer are used to make the supply to their respective clients, but are not what they supply. And that's rather similar to College of State Management, isn't it? Because college was using books in order to make its supply of education. It wasn't supplying books, at least. That wasn't the predominant element of the supply. The main thing it was what the customer, as an entirely economic and commercial desire to have education, and books was one of the means by which the education was provided. Here, the economic and commercial reality is that the client wants the names and addresses of some suitable people with whom the expert advice of Gray and Farrar have concluded there's a pretty good chance that they will make a lifetime match, and that's what they want. They want the expert advice of Gray and Farrar coupled with the information, the details of where the details of how they can get in contact with the 8 matches. So, as your Lordship said, of course, we've got to start with the contract, and that's precisely what the First-tier Tribunal did, and they examined in great length what it was that was being supplied under the terms of the contract, and they set it out in their decision. In the findings of, excuse me. Yes,
Paragraph 43, I think, is
43.
really
Thank you.
pretty much everything they say about it. And apart from a recitation of the FTT's findings of facts, it seems the contract terms seem to get lost in the
Oh, sorry, I was looking at the FTT.
43?
The terms and conditions of brief, yes. But, yes, but the tribunal went into great depths of examining the 2 witnesses as to exactly what it was that the client was doing. And the client, of course, was looking not just at the terms and conditions of the contract that was signed, was also looking at everything that was on the website that led the client to contract with Gray and Farrar. So
How would you know when signing up what is going to be provided? The website is not saying you will have an interview of this length and we will do this and we will liaise and follow up and all the rest of it. It's just saying that, you know, we've got expertise, we know the right people.
Well, the evidence from Claire Sweetingham was that before signing up there would be meetings between Claire Sweetingham and the client,
Right.
which it was fully explained to the client as to exactly what the client would be getting. We have findings of fact which aren't being challenged.
Yeah. No, well, they can't be. So that's you say that's the finding in paragraph 44, is it? About the time a client signs up to GNF's terms and conditions, a client will be interviewed.
Yes, well, that's one of them, yes. Yes.
Oh, no, wait a minute, it's 41, I think.
Yes.
41.
So
Person seeking GNS services will generally email or telephone.
yes.
After a potential client's approach, there'll be a short telephone conversation in which the extent and nature of the services and terms will be discussed.
That's it. So I would strongly submit that taking the findings of fact as a whole, which aren't challenged, they show that the First-tier Tribunal did properly look into what was being agreed between the Gray and Farrar and the client, and they made those findings, and in my respectful submission, they are unchallengeable.
Yeah.
Now, having got there, perhaps it would be best if I did go to our skeleton argument so as to make sure that I cover all the points as we deal with them. The skeleton argument is at tab 12 of the core bundle. And I think that I can safely skip the first 5 pages of it and pick it up after we've set out the legislation on page 135. First of all, did the finding that the FTT erred in law in failing to consider the application of the predominant element test. And we say that the VOB is pretty clear. You've had parts of the VOB looked at. Could I just trouble you to go back to the VOB tab 27? Starting at what was held on page 521 of the bundle, 767 of the Simon Patent report. Of course, it's only the editor, what the editor is saying, but held to on page 521 of the bundle to determine whether a single complex supply was to be classified as a supply of services in Article 6. It was necessary to identify the predominant elements of that supply. Having regard to the extent, duration, and cost of the customization, it was apparent that the customization in the instant case was neither minor nor ancillary, but on the contrary predominated. Customization of the software, of course, was of decisive importance in enabling the purchaser to use the customized software. Accordingly, the single supply of customized software was to be classified as a supply of services. So that's what the editor is saying was held. But if I could show you then the ECJ judgment starting at paragraph 18. As a preliminary point, it must be borne in mind that the question of the extent of a transaction is of particular importance to VAT purposes, both for identifying the place where the taxable transactions take place, which is our case, and for applying the rate of tax, or, where appropriate, the exemption provisions in the Sixth Directive, our protection plan. According to court's case law, then we've had that, it's the usual mantra, but then it's paragraph 22, which says the same is true where two or more elements are supplied by the taxable person to the customer, being a typical consumer, are so closely linked that they form objectively a single indivisible economic supply, which would be artificial to split. Then if we can go to 29, well, 27, I suppose. Secondly, I think we probably saw that with Mr. Singh. Secondly, with regard to the question of whether such a single complex supply should be classified as supply of services, it is vital to identify the predominant elements of that supply. Apart from the importance of the customization of the basic software to make it useful for the professional activities of the purchaser, the extent, duration, and cost of that customization are also relevant elements in that regard. And 29, on the basis of these different criteria, the Amsterdam Court correctly concluded that there was a single supply of services within the meaning of Article 6 of the Sixth Directive, since those criteria in fact lead to the conclusion that far from being minor or ancillary, such customization dominates because of its decisive importance in enabling the purchaser to use the software customized to its specific requirements which it is purchasing. And then if I can just go on to paragraph 31, my question 1C and D, the National Court asks in what place a single supply of services such as that referred to above is deemed to take place. 32, in that regard, Article 9 of the Sixth Directive contains rules for determining the place where services are deemed to be supplied for tax purposes, whereas Article 9.1 lays down a general rule on the matter. Article 9.2 sets out a number of specific instances of places where certain services are deemed to be supplied. The object of those provisions is to avoid, first, conflicts of jurisdiction which may result in double taxation, and secondly, non-taxation. 33, in respect of the relationship between the first two paragraphs of Article 9 of the Sixth Directive, the Court has already held that Article 9.1 in no way takes precedence over Article 9.2. In every situation, the question which arises is whether it is covered by one of the instances mentioned in Article 9.2. If not, it falls within the scope of Article 9.1, the general rule. To make clear that we're talking about Article 9.2 here is the predecessor of the provisions that we're looking at in this case, place of supply. To that extent, the argument that Article 9.2e of the Sixth Directive should, as an exception to a rule, be narrowly construed must be rejected. It's not an exemption, it's a place to supply rule which is there for conflict of law purposes. It must therefore be ascertained whether a transaction such as that at issue in the main proceedings comes under Article 9.2 of the Sixth Directive. And then, so carry on. 36. In that regard, the National Court is uncertain whether it is appropriate to apply Article 9.2e, third indent of that directive, which determines the place where supplies are deemed to take place for tax purposes in respect of services of consultants, engineers, consultancy bureaus, lawyers, accountants, and other similar services, as well as data processing and the supply of information. That court is uncertain in particular whether the transaction in question in the main proceedings ought not to be classified as data processing and the supplying of information within the meaning of that provision. And in their observations lodged before the court, both the Netherlands and the Commission of European Communities agree with that interpretation. In 37, it's apparent from the court's case law that Article 9.2e, third indent of the Sixth Directive, does not refer to professions such as those of lawyers, consultants, accountants or engineers, but to the services supplied by those professionals and similar services. The community legislature has used the professions mentioned in that provision as a means of defining the categories of service to which it refers. And 38 finally, in that regard it's appropriate to note that computer science, including programming and the development of software, forms a significant part of the training given to future engineers, and it may often constitute one of the various specializations available to them during that training. So, in my submission, there's nothing at all in the place of supply rules there which justifies my learned friend's confinement of it to services supplied by people in the liberal profession.
Just going back a moment to the first part of the judgment in Laval, and bearing in mind what Mr. Justice Warren said in the case, the Masseur's case.
Yes.
The court's discussion begins, as you rightly say, on paragraph 18. And what they seem to be saying in that paragraph is that you apply the same test whether you are identifying the place where the taxable transactions take place, or the rate of tax, or the exemption provisions, or whether there is one supply or two. It's the same test.
Of the extent of a transaction, yeah. They do then make clear that
they then go on
yes,
to discuss whether there's one supply or more than one.
Yep.
But the test that they propose at 18 seems to be, as it were, a uniform test.
I think, well, in my submission, that's just a very general preliminary point. Mm-hmm. What they say at 34 is quite clear, that they're rejecting the argument that 9.2e.
No, I follow. I'm not making a point against you, Mr. Mayor.
Right, you're a bit ambiguous, you might say. I think the first is a very general point. This question comes up regularly in question of the extent of a transaction. It comes up regularly in VAT, in place of supply and exemption, etc. They're not saying that any test has to be applied the same way. I would submit that's not what they're saying. They're just saying it keeps coming up, this question, what's the extent of a transaction? And then they're saying on place of supply, they're saying that Article 9.2e must not be narrowly construed.
But where
yes.
they deal with predominance, they're dealing with it in the context of deciding whether it's a supply of services or goods, aren't they? In this case.
In that particular case, yeah.
But you said also applies to a situation where you're looking at a place of supply.
Sorry, it's about, the case is about the place of supply.
The case is about whether it's goods or services.
Yeah.
But this
Yes.
part of the case.
Part of the place of supply, yeah, exactly.
The part that deals with predominant, which
Yes.
is what I thought we were
Yes,
on,
yes, yes.
is about services or goods, isn't it?
Yeah,
Have I got that wrong?
in that particular case, yes. It's no one is suggesting that predominance only applies where you've got goods on the one hand and services on the other hand. It does apply where you've got a number of different services. I don't think that's suggested by the Crown that that test doesn't apply where there's only a different types of services that you've got to work out which are predominant or not. And the definition of consultant, just to make that point, is in Gavitas, which was quoted by a tribunal case quoted by the tribunal at paragraph 68, and the tribunal, our tribunal, First-tier Tribunal, adopted the Crown's definition in Gavitas of what consultancy was. It's the provision of expert advice by someone with extensive experience or qualifications on a subject. My own friend says, oh, well, that's far too wide. That could conceivably cover other people that he was suggesting perhaps weren't consultants. I don't really want to go into that. But he kept saying that that would make far too big a gateway. But then, again, that seems to be creeping back into suggesting that we're talking about exemptions and narrowly construing things. We're not talking about that. We're talking about what is the correct interpretation of the provision for determining the place of supply. And so gateways are really, in my respectful submission, irrelevant. Now, as we say in our skeleton at paragraph 8 of the skeleton on page 136 of the core bundle, we set out paragraphs of Mesto, which being the most recent major case going into this, we respectfully suggest is the determinative authority on this subject, and we clearly rely, as did the the Upper Tribunal, on Mesto, and there's a further case of the European Court mentioned at paragraph 9 of our skeleton called Purple Parking. But perhaps just quickly before the adjournment, have a look at that. That's at tab 29. It's in the second bundle of authorities towards the end. That's about providing off airport parking, and then with transport from the parking place to the airport. And as you may have experienced, the long-term car parks are usually some distance away from the airport, and so that's what Purple Parking did. They gave you parking space, and then they would transport you from the parking space to the airport. And if you can see what was held there at page 561 of the bundle, 1681 of the report, they held that it was apparent that the parking and transport services supplied in the instant case by P&A to their customers formed for the purposes of VAT a complex single supply of services, obviously, in which the parking element was predominant. It was therefore appropriate to apply relevant provisions accordingly. And if I can just take you
I'm not sure that's what the court actually said, though, is it? They proposed a principal ancillary test rather than a test of predominance.
In Purple Parking, I was going to take you to paragraph 29 of the judgment.
29.
And 33. It is possible to interpret them as saying that it's more or less the same test, and indeed, yeah. 29 says, further as a single supplier setting up the Lvov test, where two or more elements or acts, etc., form a single indivisible economic supply, which is the article of split. That's Lvov and now other cases. And 33, they say, in respect of the dispute in the main proceedings, it's apparent that the parking and transport services supplied in the circumstances described by the Upper Tribunal by the appellants to their customers form, for the purposes of VAT, a complex single supply in which the parking element is predominant.
So if we go back to 28 in the same judgment, one or more elements be regarded as constituting the principal supply.
Yes.
Others are ancillary. So you say that and the predominance test are the same test, do you?
Well, on the particular facts of this case, they don't seem to be making a distinction between them. They're coming to the same result. And as my own friend himself said, if you apply the predominant test and you come to the same result as the overarching supply, then he'd accept it. But I would submit that the predominance test is the one that now Lvov and Mesto have laid down.
It wasn't obvious to me that paragraph 28 and paragraph 33 were saying the same thing. Paragraph 28 seems to be one of the ways in which you can have a single supply.
Yes.
Paragraph 29 is another way in which you can have a single supply.
Yes. And 33 is another one, is it?
Well, 33 is then, once you've found that there is a single supply, either on the basis of 28 or on the basis of 29,
right,
you then have to characterise the supply.
by taking the predominant element.
Yes. I mean, there's not a point that's elaborated on in that paragraph, but once you've found a complex single supply, you have to characterise it.
Yes.
Shall we leave it there for the time being, Mr. Milne?
Yes.
We've finished with purple parking.
Sorry?
Have we finished with purple parking?
Yes.
Right, well, let's leave it there and we'll resume again at 2 o'clock.
All right.